Hello everyone. In this session, we are going to discuss the concept of industrial dispute, what actually dispute means, and how this dispute uh, have a negative kind of impact when occurs in the organization. But before going through the session, we will discuss some of the objectives that we are going to achieve through this session. First, we are going to discuss the concept of industrial dispute. What are the various types of disputes that generally occurs in the organization, and what are the causes behind these kind of disputes in the organization. Finally, we'll also discuss some of the settlement machineries that are effective in settling the kind of disputes in the organization. So, starting towards this session, first, what actually dispute means? We have earlier in our earlier sessions we have discussed about the concept of grievance. What actually grievance was a kind of dissatisfaction or a kind of complaint that employees have uh, from the side of the management, and when this grievance uh, is not resolved or is not sorted out at very initial level, or and it started becoming in complex, then it takes the form of disputes. And that's why when we talk about disputes, basically it refers to the difference of opinion between the employers and workers in an industry. Obviously, on an issue, suppose employers have some another aspect, and at the same point of time workers have some another aspect, then there is a kind of difference in opinions of both the parties, and this situation somehow refers to the to disputes. And these disputes may take various forms of protest. Sometimes we can see the protests are from the side of the employers, that are known as lockouts, retrenchment, or dismissals, and sometimes protests can be seen from the side of the employees, that may be termed as strikes, heroes, demonstrations, etc. Now, according to the Industrial Dispute Act 1947, in Section 2, the industrial dispute have is being defined as the dispute or diff between employers and workmen, or workmen and workmen, which is connected with the employment or non-employment or the terms of employment with the conditions of labor or any person. Means to say that when we are talking about the difference of opinions between employers and employees, it's not just limited to the relationship between employers and employees. We can talk about the differences in opinion in employers, between employers and employers as well, or between workmen and workmen as well. Now, basically, what are the causes that leads to dispute in the organization? First of all, the concept of grievance that we have discussed already. If it is not sorted out, then it leads to the kind of dispute, and it becomes complex and complex once it is not sorted out, and it takes the form of dispute, and that we can see in the form of strikes or lockouts in the organization. Another reasons may be demand, or demand for pay and benefits high. The demand for pay increase and uh, leads to industrial disputes. A large number of strikes take place to rise in prices and cost of living. The real wages of the workers decline fast in price level, due to which they feel dissatisfied with their present uh, salary that they are getting, and they want improvement in wages. Second is hygienic and safer working conditions. The working condition in Indian industries needs to maintain hygiene. We can see lack of hygiene in Indian industries that need to be improved. Unavailability of water is there, heating, lighting problem is there, and there are less precautions management is taking regarding to safety or safety tools. This makes workers demanding, and working hours are also greater in Indian industries. Thus, that therefore, the demand of safe working condition and exhausting working hours are somewhere also responsible for the kind of labor disputes that arises in the organization. Now, next is better labor welfare and social security measures. Several provisions of labor welfare and security measures that are framed by the government that strictly needs to be executed in the organization to minimize the disputes, because government has framed these kind of legislations to save the workers from exploitation of employers. And if these legislations are not being executed, obviously that becomes a problematic thing for the employees as well as the employers, because uh, employees know about the kind of legislation that government has made for them, and if it is not being executed, it becomes a problem for the organization. So it needs to be executed, successfully executed, as well as reviewed whether it is working in a right condition or not. Now the next one is denial negotiation of trade union. We have gone through the concept of trade union as well, and basically trade unions are formed to protect the interest of workers. And if the management denies the recognition of trade union in the industries, somewhere it also leads to the industrial disputes. Moreover, the attitude of employers towards the union had never been sympathetic. They want to divide them and rule. This also leads to the kind of disputes in the organization. Next is recognition and appreciation. Uh, we have studied in the Maslow's hierarchy needs that at in employees career, a level comes where money doesn't matter. The thing that matters is appreciation and recognition. And when employees don't feel such kind of situation in the organization, then this also tends to industrial disputes, because this is one of the way that tries to maintain good relationship in the industry. And again, if this is lacking from the employer side, this becomes one of the important causes of disputes. Negligence of legislations again, as we have discussed in earlier point, that government have framed several kind of legislations, and if those legislations are ignored from the side of the management, this leads to industrial disputes. Now, there are several kind of disputes in the that arises in the organization. So we'll have a look one by one what kind of disputes can take place in the organization in what forms. First is strikes. Obviously, that is initiated from the side of the employees, and it is a temporary cessation of work by a group of employees in order to express their grievance, their complaints, or to enforce a demand concerning maybe changes in work conditions, changes in flexi hours, uh, or we can say that strikes are a result of more fundamental maladjustments, injustices, and economic disturbances as well. Second thing is lockout, that is initiated from the side of the employers, and that basically means closing of a place of a business of employment or the suspension of work. Or it may also happen that employers refuses to continue to employ any number of persons employed by him. However, if we take a look at the term layoff and retrenchment, these are not kind of lockouts. These are somewhere different from these terms are very much different from lockouts. Now, talking about the strikes, there are several kind of strikes, and strikes may take various forms from the side of the employees. Like some of the types of strikes we are going to discuss here, in which first one is stay away strikes, and basically in this strike, workmen stay away from the workplace and they organize rallies, demonstrations, etc. Through these kind of activities, they try to raise their queries and grievances in front of the management. Next is stay in or sit down strike. In this type of strike, workmen come to the place, they stay at the workplace, but they don't work. This is a kind of silent kind of presentation that they are coming to the work, but they are not working. And this somewhere is also a effective kind of strike from the side of the employees. Next is tools down or pen down strike. In this kind of strikes, what happen? Employers or workers lays down their tools in case of factory workers. And when we are talking about the white collar employees, they lay down their pens to show their kind of protest. Now, if disputes have arise in the organization, it becomes really very difficult situation to handle it if it has taken a very complex form. But there are some of the machineries through which we can try to settle out these kind of disputes. Some of the machineries that are being used without the involvement of the third parties are collective bargaining, workers' participation in management. And if these things are being continuously executed in the organization, we can prevent the kind of disputes that arise in the industry. But if it has arisen, then we need to settle it out through any of the methods. Now, it means different forms of mediation. When we have discussed the settlement of machineries of disputes as collective bargaining and WPM, but there are some issues in which the mediation of the third party is required, because without the involvement of the third party, the things are not going to be sorted out. So, when we try to introduce a third party, its main motto is to remove the mutual distrust between employers as well as employees. And there are several forms of mediation, like mediation is the also third party activity, conciliation is there, arbitration is there, adjudication is there. So first, when we talk about the conciliation, basically it is in this process the final decision rests with the parties themselves, but the conciliator may offer a solution to the dispute acceptable to both the parties and serve as a channel communication. Basically, what happens in this process, conciliator tries to reduce the distrust between the parties, and they offer a solution in front of both the parties, and it's upon the parties that they are accepting the solution provided by the conciliator or not. They are not binding that they have to accept the solution. Basically, its purpose is to remove the most mutual distrust between the employers and employees, as we have discussed earlier also. And in this process, generally a third party is involved that acts as a mediator, and they play as a key role to reach out on a voluntary settlement as well as its execution part. In conciliation, again, the ultimate decision rests with the parties themselves, and they are not bound to go with the decision that the conciliator has given to them. The parties may accept the recommendation or they may reject it. Now, the third party may be an individual or a group of people that may also term as mediators. Now, the second process to settle the disputes in the organization is arbitration. Like conciliation, arbitration is also a mechanism through which the disputes are settled by the third party, and it is a procedure in which a neutral third party studies the uh, whole case, or the whole theory and the bargaining situation. He listens to both the parties, gathers relevant information on the basis of which he or she could take the decision, and then finally they makes the recommendations that are binding on both the parties. Now, in conciliation, we have seen that the decision was not binding on both the parties, and both the parties were free to take their own decision, or they may go with the decision that were given by the conciliator. But in arbitration, what we can see that whatever recommendation our arbitrator is providing, the parties are binding to go with the decision. Now, arbitration may be classified into two parts, that is compulsory and voluntary. When we talk about the compulsory arbitration, the dispute is referred for arbitration even without the consent of the parties to the dispute. Means, if both the parties are not in the position to forward their case or their complaint to a third party, still it is being referred to the third party without their consent. That is compulsory arbitration. But in case of voluntary, the parties to the dispute voluntarily submit their dispute or their case for arbitration on the basis of their mutual understanding. However, once the parties committed themselves to the arbitration process, they can neither withdraw from the process nor they can refuse to implement the recommendations of the arbitrator. Now, the next settlement machinery is adjudication, and that means a mandatory settlement of an industrial dispute by a labor court or tribunal. Generally, the government refers the dispute for adjudication depending on the failure of conciliation proceedings. In Section 10 of this Industrial Dispute Act 1947, it is mentioned that it provides for reference of a dispute to a labor court or tribunal. In this, disputes are generally referred to adjudication on the recommendation of the conciliation officer who had dealt with them earlier. Means to say, if the case or the dispute has not yet been solved by the conciliator, by the arbitrator, then conciliator recommends that the dispute or the case must be referred to the adjudication for adjudication in which it will get a solution. In this process, the government has a discretionary powers to accept or reject recommendations of the conciliation officer. Means it's just the duty of the conciliator that he may refer the case or dispute to for arbitration, but it is government who at this stage decides that whether the recommendation of a conciliation officer will be accepted or not. And it is very much obvious that once the dispute is referred for adjudication, the verdict that is given by labor court or tribunal is binding and on both the parties. So this is the end of this session. Thank you.